And historically, corporations could not participate in federal campaigns, so they could not make independent expenditures at all. And that was the rule from 1972 when the Federal Election Campaign Act came in until 2010. What happens in 2010? This odd case of somebody who wanted to make a movie about Hillary Clinton leading up to the 2008 election, made its way through the courts up to the Supreme Court and caused the Supreme Court to seize the case as a vehicle for reevaluating Buckley and redefining what is corruption. The court held in Citizens United that corruption could no longer be just the appearance of undue influence, the appearance of buying access, ingratiation. These sort of subjective factors could no longer be considered to be corruption, quote unquote. Instead, you had to have a financial quid pro quo, dollars for political favors, just in essence outright corruption. A dollar in, a vote back. The court said that this kind of corruption, this quid pro quo corruption, can only happen with direct contributions to candidates. So contribution limits are okay for direct contributions to candidates, but they are not okay for expenditure limits and independent expenditures, being expenditures, including, and here was the shocker, the court had not, this had really not been part of the case on appeal and below, but the court actually said that this also applied for corporations. So independent expenditures made by corporations and by individuals cannot corrupt or create the appearance of corruption as long as they are independent and not done in coordination with the campaign or the candidate.
Citizens United itself, the very big case, it was a C4, cannot have campaign intervention as its primary purpose. It asserted before the Supreme Court that the film was not an electioneering communication. I looked at the 990s that were public. There's one that's missing, and they were not nice when I called them up to ask for it. They said they had no campaign intervention. They viewed this simply as a documentary. The court rejected their position, said it was an electioneering communication, and in the case, the question was the legality of corporate donors to it under the FEC, not under IRS rules. Some other issues that have been raised recently: can we require more disclosure from C4s, 5s, 6s? The Disclose Act did not pass. We don't have as much information on C4s as we get early on for C3s, because they don't have a deadline for filing their exemption application. Could we add a requirement that they file an exemption application with some period of time, so we can compare that to any 990s that are also publicly available? We do have to remember that the ability of the IRS to audit within an election cycle, however, is very limited. Okay, thank you.
I was thinking about this all the while until January 2010 when Citizens United came out. From what anyone can tell, really opened the floodgates on contributions to C4s, because now there was not only the C4 being allowed to spend as much as they want up to and including the election day, but they did not have to disclose their donors. So this was a very popular outlet for very wealthy donors to campaigns, effectively, at least 50% or whatever the determination of primary is. But they became wildly popular, and there were news reports left and right about multi-million-dollar contributions to these C4s. Some of them were even advertising that we have raised $200 million so far, please keep it coming. And then later that year, about in the fall, so these media reports are ongoing, somehow the media started paying a lot of attention to the potential gift taxation of these multi-million-dollar transfers. You can check out page 87 of the materials. started, but that got picked up in the media. It was all over the place, and someone in the basement of the IRS who works in the estate and gift tax section decided that this was a good idea, and apparently, on his or her own accord, just decided to send a few audit letters out to folks who had made contributions to C4s, but somehow failed to